Swayam Prabha. Digital India. Educated India.
Hello everybody, I am Dr. Surinder Mehra, Assistant Professor, Law Department, Banaras Hindu University, Varanasi. So, this is my second lecture in the series of this Civil Procedure Code 1908. The second topic of my lecture is place of suing. Today in morning I have discussed this section 9 that was related to jurisdiction as well as suit of civil nature. I told you like what is the importance of I mean just to understand the word civil as well as the meaning of jurisdiction and nature, all those things. So, because I told you, because I started the thing like what a first problem comes before an advocate, because you know I related it with this ki first year and second year LLB student also get this problem, like how to mug up you know this language section, order and rule, the difference between all these things. So, I told you ki like how to start and how to study this CPC. So, I related it section 9 ki instead of reading or instead of just mugging up section 9, you should understand first of all what a first problem comes before an advocate. So, in that way I told you the importance of the meaning of civil suit as well as jurisdiction. So, the second problem what comes before after deciding this question ki whether matter is civil one or not and jurisdiction issue, the second one is place of suing. Place of suing is the second topic, and this section 15 to 21A of Civil Procedure Code deals with this one, place of suing. Again you have to understand, first slide you can see these different sections also. If section 15 deals with courts in which suit to be instituted, 16 deals with suit to be instituted where subject matter is situated, like especially immovable property, 17 for immovable property situated within the jurisdiction of different courts, jurisdiction of different courts. This is section 17, different courts, and 18 where the limits are uncertain, and 19 for compensation and relating to movable property, section 19, and 20 other suits. This is the structure of this place of suing, and 21 deals with objection. So, now see this one. This second slide also talks about this one, like apart from Honorable Supreme Court, we have different several grades of courts like high courts, and second one is this district court. Just below the high court is the district court, which is the principal civil court of original jurisdiction in the district. It is also a court of appeal from the decrees and orders of subordinate court in certain cases. And third one is this below the district level, we have subordinate courts, civil judges and municipal courts. So, now section 15. Courts in which suit to be instituted. What I was telling you ki like what is the importance of place of suing? What is the importance of place of suing? So, these are the two things, and there are two objectives I have mentioned here in this slide, in below of this slide. Ki first section 15 talks about ki every suit shall be instituted in the court of the lowest grade. This lowest grade, see this one, competent to try it, lowest grade. What does it mean? Why in the lowest grade? Why not only before the Honorable High Court and Honorable Supreme Court, and why not before the higher court? Because you have to understand there are two objectives of this one, because section 15 is saying ki we should file, or every suit, civil suit shall be instituted in the court of the lowest grade, because there are two objectives of this one. If you understand these two objectives, then I do not think so. I mean, you will ask this question ki sir, why we file, why should we file in the court of the lowest grade? The first objective is the courts of the higher grade should not be overburdened with suits. You know this thing ki how many cases, civil cases and criminal cases, how many cases are pending before the higher courts, high court and before the Honorable Supreme Court, how many cases, and these overburdenedness of civil suits, overburdenedness of cases basically stopping the way of our development also. you should relate it with the development, you should relate it with the infrastructure, you should relate it with the appointment of judges and even appointment of advocates also because courts are already overburdened. So, if you really file this opportunity, if you really file your suit before the higher grade or before the court of the higher grade, then courts are already overburdened, and again I mean there would be no limit because everybody is want to get decided his or her case by the higher court. So, this first objective you should keep in mind, ki the objective behind section 15, ki every suit shall be instituted in the court of the lowest grade competent to try it. And second one is afford convenience to the parties and witness. How convenience to the parties and these witnesses? Because lowest grade or the lowest grade or as well as through this is beneficial not only for the parties as well as for the witnesses also. Where the cause of action has arisen or where the property is situated, or especially where the cause of action has arisen, so you can get easily evidence over there. You can get if you are residing over there, so you can easily approach the court also. So, that would be beneficial not only to the party, even to the witnesses also. Witness can come easily and they can get recorded their statement like in the form of chief examination or cross examination. Parties also will be, I mean this will also be convenient for the parties. Parties can also approach, they can, I mean they will not waste their money on travelling and TA, I mean travelling and I mean they will not waste their time and they will not waste their money on travelling and engaging some lawyer in some other courts. So, this will be beneficial to the parties and witnesses, because witnesses, there is a big problem of witness. If you suppose you are filing your suit in Allahabad and you are calling witnesses from Delhi or somewhere else, so then it becomes difficult for the witnesses. I mean if it is need of the case, then that is a different thing. You will pay TA and DA because this is paid service, civil matters are paid services, I already told you in your section 9 also. But if it is not necessary, then you can easily get evidence from the place, you can easily call the witnesses from that place. So, place of suing has is of great importance. Without understanding the place of suing, I mean you cannot move further. Place of suing, your case will decide the place of suing, your case will decide ki, okay, this is the right place to approach. So, the first one is the higher courts are already overburdened. So, we should relate it with the development, we should relate it, I already told you, with the infrastructure and appointment of judges and staff and number of other things. It directly a burden on our exchequer, because all these things need money. And convenience to the parties and witnesses, party can easily approach the advocate, because if you are lowest grade, it means where the cause of action has arisen, the lowest court. So, this is one thing. The provision contained in section 15 is only a rule of procedure and not of jurisdiction. The both district judges and subordinate judges have original jurisdiction over all suits cognizable by a civil court subject to a certain procedure, namely that the suit should be instituted in the court of the lowest grade competent to try it. So, this is only a procedure, basically procedure, and you have to follow procedure, you cannot go beyond this procedure also. Effect of this section 15, see this one. If a suit which under this section ought to have been instituted in a municipal court is filed in the court of the higher grade, see this one, if a suit ought to have been instituted in a municipal court and is filed in the court of the higher grade, a court of subordinate judge, or I mean is a higher grade, and such court, instead of returning the plaint to be filed in the proper court, tries the suit. See this one, I mean the question is they court should return it, but instead of returning the plaint, already told you order 7 and rule 10, return the plaint to be filed in the proper court and tries the suit, notwithstanding the defendant objection, if the defendant does not raise objection, and decree is passed against the defendant. In such a case, the decree would not be a nullity, because the subordinate judge does have jurisdiction to try the suit. This is a case of mere irregularity and not affecting the jurisdiction of the court. This is the effect of section 15, because here we are just comparing two courts, municipal court and subordinate court. And second one, see the vice versa situation. if what happens is vice versa, the position is different. If a suit which ought to have been instituted in a court of higher grade is filed in a lower court, higher court and lower court, here the comparison is with these two courts, higher court and is filed in the lower court, the latter ought to return the plaint to the plaintiff to be presented to the court of the higher grade. If this is not done and the suit is heard by the lower court, the decree would be nullity. Again the question of jurisdiction, because lower court cannot decide the issue what should be heard by the higher court of higher grade. So, place of suing, it means before filing any matter, before filing any civil suit, you must understand this thing, you must twice or thrice you should think, and if you do not understand, then you can ask from your senior advocates where to file, because otherwise a decree passed by a court without jurisdiction, and this would be equivalent to this one. First case is of irregularity. Irregularity is not that much material, although material, but not that much material. At least, I mean, this would not waste the time. But this deciding a case without jurisdiction is a big question, is a big problem, and that would, that would be, I mean, your decree would be null and void, and validity of that decree can be challenged even in execution proceeding as well as in collateral proceeding, general principle of section 9. So, these principles, you cannot study one thing in isolation, you should study or you should relate it with other provisions of CPC also, other provisions also. Then you will understand what is the collective effect of this one. This is section 15. So, here is one case also, in the case of Tara Devi versus Sri Thakur Radha Krishna Maharaj. It was held that although plaintiff valuation ordinarily determines the form, and he cannot value a suit arbitrarily in order to institute a suit in a court of his choice. I already told you this valuation, because order 7 rule 11, order 7 rule 11, this one, rejection of plaint, this deals with, there is a provision, rejection of plaint. So, plaintiff valuation, because plaintiff prepares the plaint, plaintiff will decide okay, what is the proper valuation, what is the cause of action, whether there is a cause of action or not, because he has to, according to the valuation, he has to pay the stamp duty also, court fees I mean to say. So, plaintiff valuation will decide or determines the form. If the valuation, I given the example in morning also, the consumer court district form at this, up to district level, I think 10 lakh, or in up to state commission 10 crore I think, and more than 10 crore national commission. So, this is the limit within which if your matter is there, then you can approach the district form or respective respective state commission in consumer matter and national commission. You cannot cross or you cannot go beyond that, and this is prescribed in the Consumer Protection Act itself. So, it means your valuation, this is your matter and you are deciding on the basis of your cause of action, okay, where to. Suppose you want to bring your suit within the jurisdiction of particular court, then frame your suit in such a way, or as per order 2 of CPC, frame of suit, this is in your hand, and pay court fees accordingly. Subsequently, you cannot say this thinking, no, I have forgotten this one, your lordship kindly amend my plaint, I have forgotten this one, or this was not in my mind, by mistake I have done this thing. You cannot say this, because this is your valuation, this is your cause of action. Court has no control over it. Court will decide, if the court has jurisdiction, court will decide your matter as per the valuation, as per the cause of action. If the court does not have, if your valuation is not as per the jurisdiction or your cause of action is not as per the jurisdiction, subject matter jurisdiction, pecuniary jurisdiction, then court will reject your plaint. Court will say, as per order 7 rule 11 of CPC, there is no cause of action. On the first date of hearing, court can say this one, or there is no proper valuation, there is no proper court fees. Court can say this one thing. So, this is the thing what you have to understand. Plaintiff's valuation ordinarily determines the form. Valuation, you are deciding what to claim, what is the value of your matter, what you are claiming, 55 lakh, 10 lakh, what's your claim, and pay your fees, court fees accordingly. What is your cause of action? That decide in advance you prepare this one, in advance you think this one and prepare your plaint, and then you file. On the first date of hearing, court will ask this question to you. If the court has any doubt, if the court has any query regarding this one, whether this is what is the proper valuation or what is the value of this matter, whether the court has jurisdiction or not, court can ask this question, and definitely court will ask this, because court cannot be a silent spectator if this thing is coming in the notice of the court. Then court, that is the reason why I am saying so. Court valuation, place of suing is also decided by the court of valuation. I mean this plaintiff valuation, plaint valuation, your matter valuation. This will decide the place of suing, okay, where to file and to whom you should approach, or who is the right authority from whom you can get justice in your matter. So, you should think in advance what is the, whether the matter is civil one or not, you should think in advance what is the proper valuation, and you cannot conceal this one also. If you are concealing, then subsequently also if this comes in knowledge or your opposite party brings in the knowledge of the court, then court can also demand this one, okay, pay the remaining amount, but that would not be good one, that can be with cost or anything else, with fine also. So, this is the thing, this is the effect. So, that is the reason I am saying first of all the lowest court of lowest grade, and then lowest grade does not mean that if your matter is not coming within the purview of lowest grade, then because if you say no, section 15 is saying I should file this matter before the court of the lowest grade, but as per the valuation the matter should be filed before the higher court of higher grade, then you cannot, you are not bound to file before the court of the lowest grade. This is the procedural law, this is the procedure one. If the thing is not clear, if your valuation is as per the grade, if your valuation, if the clarity is not there, then first you should move with the lowest authority. First you approach the lowest authority, then, or if your valuation is clear, if the thing is clear to you, then you can approach directly to the district court also, to the higher court also, other higher courts also. But the procedure is first you should approach the court of lowest grade, because that would be beneficial not only to you, not only to your parties as witness, as well as this will reduce the burden of higher court also. So, in collectively you should understand the meaning of this one, place of suing, section 15 to 21A. What is the importance of place of suing? Section 15 is only talking about every suit should be filed in the court of the lowest grade, does not mean that every suit, if the valuation is more than the limitation of lower court or court of lowest grade, you should think as per the valuation what is the lowest court of lowest grade in your case for your matter, then you should file. If you are getting my point, then see one next. This is section 16. Section 16 specifically, section 15 was only relating to your court of lowest grade, and section 16 suit to be instituted where subject matter is situated. So, you can write down on this point, or you can understand this point, immovable property, immovable property. You can write down it also on section 16, or I mean section 16 instead of reading this suit to be instituted where subject matter is situated. So, you can understand it with the immovable property. This section 16 is dealing with the immovable property. Under section 16, I am reading the language of this section 16, subject to the pecuniary or other limitation prescribed by law, suit for the recovery of immovable property with or without rent or profit. See this one, A, B, C, D, E, F, these 6 points are there. The first one is recovery of immovable property with or without rent. If it means relate it with the rent, I mean if you want to claim any rent relating to immovable property, with or without rent or any other profit relating to immovable property. And what is immovable property? The property which is embedded in the earth, which is attached with the earth, your houses or your other kind of immovable property. You should see the definition of this one, immovable property, which is embedded and attached with the earth, that is immovable property. So, if you have any problem relating to immovable property, if you want to file the suit relating to immovable property for claiming rent with or without any rent or with profit, any kind of profit, it does not mean okay, just recovery of immovable property, does not mean that. It means if you want to claim any rent relating to immovable property, if you want to claim any profit, for example mean profit, then also section 16 would be helpful for you. It means you will file if you want to claim any mean profit, if you want to claim any rent, if you want to claim any other profit, then you will file where the immovable property is situated. You cannot approach any other court. If your property is situated in Varanasi, then Varanasi court is the right authority. If your property is situated in Allahabad, then Allahabad is the right authority. Allahabad court is the right authority. You cannot go here and there because your property is situated there. And again there is the importance of this one. You can get easily because property, if the property is situated in Varanasi, then you can get evidence easily over there. You can get any other information also relating to there. If you want, I mean local commissioner, appointment of local commissioner under order 26 of CPC, then also you can easily appoint and local commissioner can easily visit the property. Okay, who is in possession, who is not in possession, what is the status of property, immovable property I mean to say. So, for all those things, and that would be convenient because ultimately you have to pay the amount, you have to pay the money, T and D of local commissioner, apart from it witnesses to whom you want to call in favor of your case. So, again this is related with that point also. So, section 16 is saying where the immovable property, recovery of immovable property, rent or profit or any other. Second one, partition of immovable property, partition you understand it. If you want partition of your immovable property, suppose there are 4 brother or 3 brother, if they want partition of their property, that matter would also be filed. Again here just out of these 6 clauses A, B, C, D, E, F, you have to understand that this can be the kind of matter relating to immovable property, because we understand only, or I am telling you only that there is immovable property which is embedded and attached with the earth. But you have to understand that this can be the matter relating to immovable property. The first one is, for example, I have told you already, recovery, rent, profit, and second one is partition related matter. No need to think over it because this is, if the partition is related to immovable property, where the property is situated, you will file your matter there. Third one is foreclosure, sale, redemption in case of mortgage or charge upon immovable property. See this one, these are 4 or 5 kind of things are there. Foreclosure, sale, redemption in case of a mortgage or charge upon immovable property, anything relating to charge upon immovable property, foreclosure relating to sale, if you want to sell, or redemption in case of mortgage, that would also be filed. See, you have to read out it, I mean very because from examination, competition examination point of view also, these 6 kinds are there and these minor points, the small things you should take into account, because question can come from these points also, these clauses also. So, next D, for the determination of any other right or interest in immovable property, determination of any other right, that depends upon varies case to case, any other thing what is not covered by section 16, then that can also be, if there is any problem relating to any immovable property or determination of any right, other right relating to immovable property, that would also be filed as per section 16 of your CPC, because section 16 is talking about where the immovable property is situated. Section 15 was telling only in the court of the lowest grade, that is not applicable here, lowest grade. This is section 16 is talking about absolutely, this is separate provision, immovable property, mind it again, immovable property, lowest grade is something else, that is the simple procedure, okay, every matter should be filed in the court of the lowest grade, but that would not come here in section 16. E, for compensation for wrongs to immovable property, compensation for wrongs, if you claim any kind of, if you have any compensation relating to immovable property, then also you should file your matter where the property is situated. And last one, for the recovery of immovable property actually under distraint or attachment, this is very important aspect, F especially. For the recovery of movable property actually under distraint or attachment, if you have heard about, you know, execution procedure order 21 of CPC, execution means to realize the fruits of your decree through judicial process. to realize the fruits of your decree through judicial process as per order 21 of CPC. After getting decree, if your judgment debtor is not good one, then you will approach again the executing authority, executing court, in order to get realize the fruits of your decree. So, then section 60 of, keep it in mind, apart from order 21, order 21 is also relating to, this is execution, and section 16 property which can be attached and which cannot be attached. Section 60, this is section, not anything else. Section 60, property which can be attached and which cannot be attached. The list is there in section 60 itself. So, here section this clause F is saying, for the recovery of movable property actually under distraint or attachment. Movable property, because if the court is attaching your property, suppose Varanasi court in case of any decree is attaching your property, then also section 16 will be applicable. You cannot say these things, ki sir, no, this is movable property, sir, court has attached our movable property, but no, because this is only one of the one exception. What you have to understand, if Varanasi court is attaching your property in case of execution, then you can claim the realization, the recovery of that movable property from that court which has attached your decree, the property, movable property, under distraint or attachment, attached property. So, for that you have to understand the entire concept of execution, because we have section 51 of CPC, the kinds, the mode of execution. The first one is specific recovery, specific delivery. Second one is attachment of property with or without sale. Third one is arrest and detention. Fourth one is appointment of receiver. Fifth one any other ground. So, these are the 5 mode of execution. So, second one is attachment with or without sale. If perishable item, then with sale. If without item is not perishable one, then without attachment, without sale. There can be attachment of your property, depends upon if you are judgment debtor, you are not giving the fruits of decree to your decree holder. Decree holder means the in whose favor the decree has been passed, and judgment debtor against whom the decree has been passed, against whom the decree has been passed, that is called judgment debtor, and decree holder in whose favor. In definition clause you will find all these definition: decree, judgment debtor, decree holder, legal representative, and all those things, mean profit, order, all those definitions you will find there. But just in simple language I am telling you, decree holder means who is holding the decree, in whose favor the decree has been passed, and judgment debtor against whom the decree has been passed. So, here I am telling you ki where to file, because these 5 clauses A, B, C, D and E, these are very much easy and clear one, ki because this is directly talking about ki these are movable, relating to movable property, immovable property. But this F clause is very much difficult one, because this is talking about for the recovery of movable property actually under distraint or attachment. So, that is the reason I have given the examples of what is execution, what is the meaning of execution, what are the modes of execution, what is section 60, attachment, property which can be attached and which cannot be attached. So, if you understand all those things, then you will understand ki okay, civil court has very much power to attach the property, movable property, immovable property. So, here in case where if the property has been attached by one court, then you can file your matter before that court only. So, are to be instituted in the court within whose jurisdiction the property is situated. See this one last point, where the property is situated, but just you have to understand here this is F clause is little bit complicated, otherwise rest of the things are very simple and easiest one. So, you should understand this one. If you are getting this point, what is the attachment or attachment of movable property, then there is no problem with section 16 also. Got my point? So, suit to be instituted where subject matter is situated. So, you should write on in your bare act itself or with section 16 ki this is related with immovable property. There are 2 kinds of property, movable and immovable, and now there is third one also, intellectual property. For that there is a provision in the intellectual act itself, intellectual property act itself, IPR I mean to say. So, movable property and immovable property. Immovable property, where immovable property is situated. For movable property, we have section 19, we have section 20 also equally applicable. Section 19 and 20, I will discuss it in my further slides. So, movable property which can move easily from here to there, that is movable property, like table or anything else, chair or anything else which can move. And immovable property which is embedded in the earth, which is attached with the earth. There is in Registration Act 1973, I think, I mean the definition of immovable property is also there, and apart from it also you can read it out. I mean this act is also there, you can come to know what is immovable property. So, this is all about section 16. However, a suit to obtain relief respecting or compensation for wrongs to immovable property held by or on behalf of the defendant may, where the relief sought can be entirely obtained through his personal obedience, be instituted either in the court within the local limits of whose jurisdiction the property is situated, or in the court within the local limits of whose jurisdiction the defendant actually or voluntarily resides or carries on business or personally works for gain. So, property means, the term property means property situated in India. The term property, this is also one thing, clarification relating to this one. Property means property situated in India. This is another thing, I mean suit enumerated in clause A to F must be instituted in the court within the local limits of whose jurisdiction the property is situated. I have already told you this one, but again I am reading it, just if something new comes I will tell you. As a rule, therefore, courts have no power to decide on right and interest in property situated outside their local. Court have no power to decide right and interest in property situated outside their local jurisdiction. But the section does not preclude the court from trying any question in respect of property lying outside their territorial jurisdiction, where such a question arises incidentally. Incidentally, if question comes, like you are filing just before thinking, or after thinking, if you are filing, Varanasi court has jurisdiction, but subsequently the question comes before the court, no, this is not the area of Varanasi district court, this is the property of Allahabad jurisdiction, then that is a different thing. Then court will take into account all these things. I will tell you section 17 and section 18 are there. In case of uncertainty, in case of the property situated on two border, then also we have provision for that one. It may be noted that clause E applies to torts to immovable property such as trespass, nuisance, etc. Such suit must be instituted in the court within the local limits of whose jurisdiction the property is situated. Trespass, already cleared this one. Any other matter, like see this one, again for compensation, E clause of this one, section 16, for compensation for wrongs to immovable property. So, here we have this example like trespass and nuisance related matter, because you claim compensation for those things. For trespassing, for nuisance, you claim compensation. If there is a trespass on your immovable property, if there is a nuisance on your immovable property, then such suit must be instituted in the court within the local limits of whose jurisdiction the property is situated. So, then also you will file your matter where the property is situated. Keep it in mind, again and again I am repeating this one. E and F clause. E is talking about like compensation relating to immovable property, compensation for trespassing, for nuisance, for this kind of things. If these things are, if you are claiming any compensation, if you are claiming compensation for trespassing, if you are claiming on immovable property, if you are claiming any compensation for nuisance on immovable property, then also you will file the matter. Just for your understanding, otherwise the thing is not something new, just for your understanding what is compensation related to immovable property, what is F, movable property, attached movable property or distant movable property, F clause. So, for those cases also section 16 will be applicable, because this is very something new, because on the surface it appears like if the matter is of trespass, this is relating to something else, other suits, or this is relating to something else, movable property, nuisance, not directly we are claiming immovable property, we are claiming compensation for nuisance, we are claiming compensation for trespass. It appears for the beginners, I told you, and even first year and second year student also get confused with these few things. But you should understand how this is, because this is related with the immovable property. So, that is the reason I am saying or emphasizing this one, no, if these things are there, then only section 16 will be applicable. The proviso to section 16 is based on the well known maxim equity acts in personam. It means whereby the court looks for the fulfillment of its decree to the person of the defendant. The court can give relief in suits respecting immovable property situated abroad by enforcing the judgment by a process in person, by enforcing the judgment by the arrest of the defendant. The court can give relief in suit respecting immovable property situated abroad by enforcing the judgment by process in personam, by arrest of the defendant, by attachment of his personal property. But in order to do this, it is essential that the defendant must either reside or carry on business or personally work for gain within the local limits of the court jurisdiction. So, this is also important thing what you must understand and what you must notice, like for this kind of property also situated abroad, then also, and these are the all mode of execution, like enforcing the judgment by process in personam, arrest of the defendant, attachment of his personal property. These are all mode of execution as per section 51 of CPC, execution order 21, section 51. So, this is also you have to understand. Section 17, we have next one, suit where immovable property is situated within jurisdiction of different courts. This is this one important, different courts, where the thing is not clear to you. Section 17 lays down that where a suit is filed to obtain relief respecting or compensation for wrongs to immovable property situated within jurisdiction of different courts. Sometimes this kind of problem comes, different courts, two courts, because this thing territories are changed by the respective high court, respective state government. They can change if the particular area is coming within the area of Varanasi, then subsequently after 5 years or 10 years this can be changed and the same area can come within the jurisdiction of Allahabad or some other district. So, this can happen. So, in this kind of, if the property is situated on border, I give just this example, if the property is situated on border of two districts, this is Varanasi and this is Allahabad, this is this one. If the property is situated on border, then the wrongs to movable property situated within jurisdiction of different court, the suit may be instituted in any court within whose jurisdiction any portion of the property is situated. Now, this is the thing in your hand, in the hand of the plaintiff who is approaching the court. So, party can file either, can approach either Varanasi court or Allahabad court by taking into account or by pleading this thing before the court, your lordship, the property is situated on border and I do not have. But you have to prove this thing, you have to justify thing before the court. It does not mean that just by saying this one, okay sir, I had no idea or whether this court has jurisdiction or not. Like see this one. However, in such cases the entire claim in respect of the value of subject matter of the suit should be cognizable by such court. This is also another thing what you have to keep it in mind. Before filing you can approach any court, no problem, but the subject matter property, value of subject matter, this is also valuation, value of subject matter, whether this court, particularly if you are approaching the Allahabad court, whether this court has jurisdiction, or within the district also whether this court has jurisdiction, subject matter jurisdiction or valuation, pecuniary limitation, pecuniary jurisdiction or not. It is to be noted that section 17 is only permissive and where the properties are situated in different jurisdiction, the section is no bar to party bringing separate suits. You can file separate suits also. The object of this section is to avoid plurality of suits. Before the provision of this section can come into play, there must be one property which is situated in different jurisdiction. Just to avoid this one, otherwise if because the property is situated on border and you can approach Allahabad court and Varanasi court also, then definitely again this would become or this will overburden the courts and there will be two cases. So, to avoid this one, this provision has been kept in CPC section 17 where the property is within jurisdiction of different courts. So, then you have very much right, you can approach the either court, any of the court, in any court within whose jurisdiction any portion small or big one is of the property situated. You have to understand this, then you should take into account this provision section 17. Section 18 where the uncertainty is there, uncertainty ki okay, where to file, see this language of the section 18, where it is alleged to be uncertain within the local limits of the jurisdiction of which of two or more courts, where it is uncertain, this is alleged uncertain within the local limits of the jurisdiction of which of two or more courts an immovable property is situated. Any one of those court may, if satisfied that there is a ground for the alleged uncertainty, record a statement to that effect. If you allege ki no, your lordship, there is uncertainty, then and court must, I am relating to immovable property, there is uncertainty, any one of those court if satisfied, and satisfaction based on your plaint, satisfaction based on your pleading, how you are satisfying or justifying the thing before the court, ki okay, ki there is a uncertainty sir, there is no clear cut direction, there is no guidelines on this point, then and court will take into account your submissions. So, for alleged uncertainty, record a statement, court will record this statement to that effect and thereupon proceed to entertain and dispose of any suit relating to that property. The decree of such a court in the suit will have the same effect as if the property was situated within the local limits of its jurisdiction. Very simple. Court will record that your submission ki okay, as per the pleading of the plaintiff or as per the pleading of the defendant, ki the property is situated here and there is uncertainty relating to this one immovable property, then and court is very much satisfied with this one ki really this doubt is there because there is no clear cut direction and court is satisfied with the pleading of the plaintiff, then there is no problem. Court will move further and court will pass decree accordingly, and there is no difference of effect also. Court would, I mean the suit will have the same effect as if the property was situated within the local limits of its jurisdiction. In such a case, it is presumed that the suit is one with respect to which the court is competent as regard the nature and value of the suit to exercise jurisdiction. I mean, if in case of this uncertainty, this is the thing, this is presumed, taken guaranteed, presumption is there, although this can be rebuttable one, but depends upon, because you people are, plaintiff is stating before the court, if defendant rebut it, then that is a different thing. But otherwise, if there is no rebuttal, then court would presume this one ki court is competent because there is uncertainty and this is coming through pleading and the court has very much jurisdiction over the nature and value of the suit. Then court will entertain your matter and court will move further, no problem with that. It is further provided that if a statement has not been recorded by the court and an objection is taken before an appellate or revisional court, that a decree or order in a suit relating to such property was made by a court not having jurisdiction where the property is situated, the appellate or revisional court cannot allow the appellate or revisional court cannot allow the objection unless in its opinion there was at the time of institution of the suit no reasonable ground for uncertainty as to the court having jurisdiction with respect thereto and there has been a consequent failure of justice. I mean, if you do not raise this objection, if you have any objection, if you had any objection, then at least appellate or revisional court will not take into account unless and until there is a complete failure of justice. Appellate court and revisional court will not entertain your plea ki no, now you are saying ki no, your lordship, there was no certainty, there was no uncertainty. Now earlier you were saying ki because you agreed on this point, there was uncertainty when plaintiff was pleading this one, why didn't you raise objection that time? Now you are saying ki no, your lordship, there was no uncertainty, I mean the court wrongly entertained this suit. So if you take this plea before the revisional court and before the appellate court, first appeal or revision before the Honorable High Court, revision 115. So if you raise this objection, the court will not entertain your, this is not a failure of justice. Yes, if there is a failure of justice, if you say ki no, your lordship, I raised my point, but the court did not appreciate it, or at least the court marked it, then court will take into account this one, okay, really this doubt was there and he raised this point ki that in its opinion, unless in its opinion there was at the time of institution of the suit no reasonable ground for uncertainty as to the court having jurisdiction with respect and there has been a consequent failure of justice. So if this thing was there, consequent failure of justice is there, then court can entertain your plea also, appellate court and revisional court relating to uncertainty, and court can, and the court will exercise their power, revisional court and appellate court, you know this thing, the power of appellate court and the power of revisional court. Section 19 now. So, section 15 deals with the court of the lowest grade. Every suit shall be instituted in the court of the lowest grade. This is the first one, lowest grade. At least you will try कि okay, as per the valuation of your matter, as per the subject matter of your matter, subject matter of your case or valuation, this is the lowest grade. This is the first court. That is section, that is dealt by section 15. 16 is dealing with relating to immovable property, where immovable property is situated. 6 clauses I told you, A to F. Okay, these are the matter relating to immovable property, where the property is situated. And what is the object of this section? Place of suing. I already told you that this is a provide convenience to the parties and witnesses, and remove the sort out the problem of overburdenness of the higher courts also. Otherwise, everybody, because people have money, they want to get decided their case by the higher courts. So, that this is also one of the provision ki okay, no, this is the section 15. You can approach, if you want to approach in your case, then first the approach the lowest court of lowest grade. And section 16 immovable property, section 18 17 in case of different courts, and section 18 uncertainty point, if there is an uncertainty, and different courts I already told you okay, any court as per your choice, as per your convenience. But for section 18 there must be an uncertainty, because section 17 dealing with any portion of the property is situated, then you can move. And section 18 is talking about uncertainty, that when the thing is not clear to you, the thing is not clear even to court also, only then court will accept, because court has to record the statement, otherwise court will reject. No, there is no cause of action, court will not, the court has no jurisdiction at all, then court will reject your application, plain time mean to say. So, uncertainty, the uncertainty should be in your mind, uncertainty should be in the mind of the court, then court will note. Or if the uncertainty is there and court is also accepting this uncertainty on the basis of your pleading, court will move further. Section 19, suits for compensation for wrongs to person or movable property. Section 19. Under section 19, if a suit is for compensation for wrongs done to person or to movable property, if the wrong was done within the local limits of the jurisdiction of one court and the defendant resides or carries on business or personally works for gain within the local limits of the jurisdiction of another court, the suit may be instituted at the option of the plaintiff, in either of the said court. There are 2 illustrations of this point, and with this illustration, this is very easiest section. If the wrong was done within the local limits of the jurisdiction of one court and the defendant resides or carries on business, defendant, these are the 3 places: defendant resides, residence of defendant, resides. See this one, this is first one. Second one is carries on business, this can be another place of jurisdiction. And third one, personally works for gain, personally works for gain, personally works for gain. Normally I give this example. Suppose you are residing in Varanasi and you are carrying your business in Chandigarh and personally sitting in Allahabad. So, these 3 places are there. So, suppose for example, take this example, A reside in Delhi, beats B in Kolkata. So, B may sue A in Kolkata as well as in Delhi. So, it means B will get 2 places of their matter. In Kolkata also he can file, and in Delhi also he can file his matter. A residing in Delhi published in Kolkata statement defamatory of B, B may sue A either in Kolkata or in Delhi. So, these 2 places. A residing in Delhi published in Kolkata statement defamatory of B. So, B may, it means A is defendant and B is plaintiff here. So, B may sue A either in Kolkata, because see this language, defendant resides, carries on business, personally works for gain, and with another example you will understand more about this one. But this is the thing relating to movable property, you have more choice where the cause of action arisen partly or wholly. Section 20 talks about it. So, see this one, although this is related with other suit, but equally applicable to section 19 also. See this one, section 20 provides that subject to all the limitation discussed above, every suit is to be instituted in a court within the local limits of whose jurisdiction the defendant or each of the defendant where there are more than one there can be more than one defendant, you know this thing, co-defendant, co-plaintiff, concept of co-plaintiff, order 1 of CPC talks about parties to suit, plaintiff and defendant, and there can be again co-plaintiff and co-defendant. So, if there are more than one defendant, then at the time of the commencement of the suit, actually all voluntary resides or carries on business or personally works for gain. These words, separate interpretation you should take or you should do, separate interpretation, ki what is the actually resides, voluntary resides, carries on business, personally, these four words, actually resides, where actually he resides, defendant I mean to say, where he voluntarily resides, there can be two places of residence, actually he is residing in Varanasi and voluntary he resides sometimes, I mean sometimes he spends in even in Kanpur also. So, actually resides, voluntary resides, carries on business, he is carrying business at different places, personally he is personally sitting because somewhere he is getting his work done through manager or some other agent and personally he is sitting somewhere else. So, these different places of jurisdiction you will get and you can file your matter over there, because defendant where there are more than one at the time of the commencement of the suit. Any of the defendant where there are more than one at the time of the commencement of the suit actually or voluntary resides, B1 carries on business, personally works for gain, provided that in such case either the leave of the court is given or defendant who do not reside, carries on business or personally works for gain, acquiesces in such institution. This is also very important. If any defendant, suppose there are 4 or 5 defendant and any one of the defendant raise objection ki no, you cannot file here, then in that case, because ultimately plaintiff has to file suit and one of the defendant raise objection, no, Varanasi is not the right place, you can file Allahabad, you can file Kanpur, but the plaintiff wants to file suppose in Varanasi and the Varanasi defendant is saying ki no, Varanasi is not the right place, I will not, I mean you cannot file, I will not let you file this matter here. Then in that case either permission of the court, it means leave of the court, you can get permission, the plaintiff can get permission from the court or through consent. This is the work what has to be done by the plaintiff. Plaintiff either he should take permission from the court ki no, your lordship, he is raising objection, tell me where to file or grant me permission, I want to file here in Varanasi and he is also residing in Varanasi, or he can take consent also outside the court from the defendant itself ki no, please give me permission, I will file here. But if he is ready then it is okay, but otherwise permission of the court is there, you can take permission, submit this plea before the court and court will grant permission definitely. And third one is cause of action wholly or partly arises, where the cause of action wholly or partly arises, wholly, completely or partially arises, that is also the place where you can approach the court. Got my point? This is section 20 order, I mean relating to other suits. We have illustrations also relating to this one, I mean like with these examples also you can understand what is the relevance of section 20 and what is the important, I mean application of section 20. Suppose A is a tradesman in Kolkata, B carries on business in Delhi, B buys a gent in Kolkata, buys good from A and requests A to deliver them to the railway company. A delivers the good accordingly in Kolkata. A may sue B for the price of the good either in Kolkata where the cause of action has arisen or in Delhi where B carries on business. If you understood the illustration of section 20, I mean these clauses A, B, C, then there is no problem with this illustration also, you can easily come to know. I already told you what is the meaning of actually residing, what is the meaning of voluntary residing, what is the meaning of personally working for gain or carrying on business, or where the what is the meaning of cause of action wholly or partly arises. This is you have to understand. So, it means this gives basically more choice to the plaintiff ki okay here also, but in case of immovable property section 16 ki only where the property is situated, but here in case of movable property and other miscellaneous kind of matters then you get an opportunity. In case of movable property also you get this opportunity, you get more choices, you can file your matter anywhere as per the section 20 or section 19 and section 20 respectively. Section 20 is a general section covering all personal action, suit relating to person or movable property, and as the opening word state, it is subject to the other limitation contained in section 16 to 9. Whoa, that is a different thing ki whether the pecuniary limitation is there or subject matter limitation, you have to keep it in mind before applying section 19 and 20. That is a different thing. I mean, I already told you ki yes, in I mean collectively you have to understand, because if the Suppose you want to file your matter before the Varanasi court because Varanasi defendant is residing there, but that court has no pecuniary jurisdiction, that court has no subject matter jurisdiction, then in that case you cannot approach. So, these limitations you have to keep it in mind, ki subject matter limitation, pecuniary limitation, or exclusive and concurrent and original and appellate, all those things what I told you. So, jurisdiction, territorial and local limits, all those limitations you have to keep it in mind, because without this the court would get no authority if the jurisdiction is not with the court. Section 20, leave of the court. Leave of the court is required when some of the defendant are with and other are outside the court jurisdiction, and this is the judgment also Narayan versus State of Secretary of State, in Dwarka Das versus Hanuman Das also, ki leave of the court can be given at the stage of appeal. However, such leave is not to be granted only by asking, and there is an obligation on the court to consider the position of the non-resident who does not appear, and as well as all those implications. Practically court has to see this thing, ki what is the problem with that. And cause of action means bundle of essential fact, means cause of action or set of circumstances which leads up to a suit. It may be defined as being the fact or fact which establish or give rise to a right of action, or I mean no need to tell you what cause of action means. Basically in simple language I can tell you ki this is the bundle of essential fact. Cause of action basically is the base of your case. If there is no cause of action, because we are relating it with section 20, cause of action wholly or partly arises. So, cause of action means basically the bundle of essential fact, that is the base of your case. If there is no cause of action, if there is no legal cause of action, then you cannot approach the court. On the basis of social and on the basis of moral cause of action, can you approach court? No, you cannot. So, there must be a legal cause of action, there must be a relevant fact, there must be a genuine problem, there must be a violation of your legal right, civil right, there must be a violation of your civil right. Only then you can approach. So, you have to understand this is the cause of action. Without understanding cause of action, you cannot. In section 9 I already told you cause of action, ki whether matter is civil one or not. Civil means private right and remedies. So, cause of action you have to, in the beginning itself you have to understand. Without it you cannot decide the place of suing. What is cause of action? Although this I mean illustration or some points have been given here, you can understand with this one also, but in simple language means bundle of essential fact, that is the base of your case. Otherwise court will reject your application if there is no cause of action. On the first date of hearing itself, court will not entertain you. Court will ask you, ki, okay, what is your problem, Mr. Advocate? What is your problem, Mr. Client? Is it really genuine one or not? Because sometimes there can be fake one also, there can be fabricated kind of things also, there cannot be, I mean, legally recoverable or enforceable matter also. All those things you have to keep it in mind. So, cause of action means bundle of essential fact. These are the objections relating to section 21, ki at the earliest, just in few points I will cover, at the earliest possible opportunity. As to objection as to place of suing, it means you must take at the earliest possible opportunity, because this is the duty of the advocate and duty of the client also, if you are smart enough, if you are literate. But this is simultaneous, this is duty of the advocate also, because they are smart enough and also, and they are I mean they know the case also. At the earliest opportunity, subsequently you cannot say no I have forgotten, by mistake I have done this thing, I could not raise this objection earlier. You cannot say this thing. At the earliest possible opportunity, at least you must get it recorded. You should raise this point before the court. Whether court is appreciating it or not, that is a different thing, but you must get it recorded. Sometimes court can say no overruled or sustained, that is the I mean answer of the court, but at the earliest possible opportunity, before I mean during the hearing, during the trial of the case. If there is a objection as to place of suing, defendant must raise this one, because plaintiff will try to show this thing, no, the court has this is the right place, this is the right court. So, being a defendant, this becomes the duty of you. No objection as to the competence of court with reference to pecuniary limits shall be allowed by any appellate or revisioner unless such objection was taken in the court of first instance at the earliest possible opportunity. This is what I have already told you. And competence of the executing court with reference local limit shall be allowed by any appellate or revisional court. Again the same things are there, ki yes, unless and until there is a complete failure of justice, because failure of justice is the justice, providing justice is the important thing. Court has to keep this thing in mind ki whether, I mean, there should not be defeat of justice. There should not be defeat of justice. For the defeat of justice, court can take into account other things and can exercise inherent power also. See this one, I have summarized it. These are the general principles, and in summary form, I mean from section 15 to 21 you can take into account. The first one is every suit should be instituted in the court of the lowest grade. This is first one, section 15. The court of the higher grade is not deprived of the jurisdiction to try, higher grade is not, because this would be only irregularity, not want of jurisdiction. Once the suit is properly instituted, the court has power to pass a decree exceeding its pecuniary jurisdiction, properly instituted, like higher court can exceed as for the interest of justice. Relating to movable property, where the property is situated, section 16, and for movable property, where the wrong is committed, it means where the cause of action has arisen or defendant resides, these things, section 19. Other suit for section 20, and consent can neither confer nor take away jurisdiction of a competent court. I already told you in section 9 also, consent cannot, you have to move as per section 15 to 21A of this CPC. You cannot decide your place of suing on and on. Whatever is there in the provision, you have to move by that. Where two or more courts have jurisdiction to entertain a suit and parties agree to submit to jurisdiction of one of such court, the agreement is legal and valid. Where two or more courts have jurisdiction to entertain a suit and parties agree to submit a jurisdiction of one of such court. This is also one thing important. My statement is not contradictory one. I already told you, frames your suit in such a way as per order 2. If you leave something, then it is okay. You are trying to bring your suit within the jurisdiction of this court, then there is no problem, the agreement is legal and valid one. But if you are not framing, you are framing something else and claiming something else and filing before the court. So, court has to take into account this thing, whether this court has jurisdiction or not. How court can decide this matter on which the court has no jurisdiction? So, agreement is valid when you frame in such a way. So, no objection as to territorial or pecuniary can be entertained by appellate or revisional court, or section 21 I already told you, at the earliest possible opportunity, or failure of justice also, I mean for the justice point of also, court has to keep it in mind. Court cannot defeat the justice. So, these things you have to keep in some summary form. This last slide of this topic, place of suing, general principles. So, this will cover your entire section 15 to 21A. So, this is all about place of suing, guys. So, this was my second topic or second lecture. I will cover only important topics of CPC. So, in first lecture I told you what is section 9, suit of civil nature as well as jurisdiction of civil court, and section 15 to 21, this is relating to place of suing, where to file, because this is the second problem. After deciding whether matter is civil one or not, then second problem you have to sort out by filing your matter before the right authority, that is as per the place of suing. So, this is all about section, place of suing. Thank you.